In this video, we'll look at the law on firing and rehiring, at proposals for reform of it, and at a recent case where a fire and rehire dismissal by a firm of lawyers was held to be unfair. Many employers have changed terms and conditions during the pandemic, whether to access the furlough scheme or to enable the survival of the business through economically unprecedented times. Some employees have been willing to agree to those changes, keen to avoid a redundancy situation. If an employee refuses to change their contractual terms, an employer can't change employment terms without their agreement. So giving lawful notice to end the contract and offering a new contract in return, known as firing and rehiring, is a safer option, provided the employer has a sound business reason for making the change. The dismissal is likely to be fair, provided the employer has gone through a fair procedure, including detailed consultation before firing. Fire and rehire has been brought into the spotlight recently by the widely reported British gas case, where employees were given notice to end their existing contracts and asked to agree new terms for lower pay and longer hours. Hundreds refused, and so their employment terminated. An Observer poll found that 9 out of 13 companies firing and rehiring this year maintained healthy profit margins. Now, that headline may be misleading, of course. It seems to disregard the fiscal responsibilities that businesses have to shareholders, and it underplays the impact of declining profits. British Gas's profits have halved over 10 years, and this year it reported its weakest earnings on record. There is at the very least an argument for allowing companies such as that to address the downward trend. Professor Alan Bogg, a professor of law at the University of Bristol, has argued that under the current law, the balance of power lies too much with the employer, and that a determined employer with the right advice can achieve its goal of reducing terms and conditions with relative ease. He argues for a number of reforms that could provide greater protection to employees in these cases. His proposals include making protection from dismissal a right for all employees, not just those with over 2 years' employment, in cases of dismissal and re-engagement, and changing the law to provide that dismissal and re-engagement will be unfair if the employer had reasonable economic alternatives to firing and rehiring. The government asked ACAS to investigate fire and rehire and received ACAS's report in February 2021, but the content of the report has not yet been published, despite requests from members of Parliament. MPs have debated the issue recently too. Government representatives indicated that they need to tread carefully when considering government intervention in commercial or contractual matters between employers and employees. There was a widespread belief that provisions to limit fire and rehire would be included in the Queen's speech in May 2021, but there was nothing there. The government has now said it will look at the issue when parliamentary time allows, so the can has been kicked down the road for now. Fire and rehire should always be a last resort. The pandemic has shown that employees faced with the threat of redundancy are often willing to accept new, less favourable terms in order to protect their long-term employment. Now, communication is the key here, as is considering what cost-free sweeteners can be offered alongside pay or benefit cuts. The last year has shown us that benefits such as flexible and home working are considered priceless by some employees. Fire and rehire shouldn't be banned, but it should be used sparingly when all other methods have been exhausted and there's really no other option. Now let's look at a recent case where the courts looked at fire and rehire. In Khartoum against Wynn Solicitors, the employer, a firm of solicitors, experienced a downturn in work due to the pandemic. It decided to furlough half its staff, with the other half retained to do the remaining work. All employees were required to sign new contracts or face dismissal. The new terms gave the firm the right to furlough staff or reduce their hours and pay on short notice. One employee, Miss Katoon, refused to sign the new contract, saying she wouldn't sign it now, but she'd consider furlough or consider a reduction in hours in future if the situation arose. She was urged to reconsider, but she refused to sign the new contract. She was dismissed without notice, or indeed accrued holiday pay, because the chief operating officer was, quote, fuming. Her remote computer access was removed even before she was told about her dismissal. The employer later accepted they owed her notice and holiday pay and paid it. She brought an unfair dismissal claim. The Employment Tribunal, and it's only an Employment Tribunal case, not an appeal case, the Employment Tribunal agreed that she had been unfairly dismissed. It acknowledged that the business had sound good business reasons for changing the contract. Given the effect of the pandemic, it was reasonable to request the changes, and it wasn't premature. Theoretically, the dismissal was potentially fair, but the employer hadn't behaved reasonably overall. The tribunal agreed that only one employee out of 300 had refused to sign, which indicated the business had acted reasonably, but there'd been no meaningful consultation at all, just a one-sided conversation. Although a subsequent phone call had looked a little bit like consultation, the tribunal didn't believe meaningful consultation had taken place. The employer didn't explore alternatives, and instead it just reiterated the firm's position. The firm argued it didn't have time to negotiate with 300 staff, but the tribunal thought that was a misleading response because it didn't need to negotiate with 300 staff. 299 of them had agreed, so only one of them had to be fully consulted with. The tribunal was surprised that a firm of solicitors had so little regard for a binding employment contract and an employee's desire to protect her contractual terms. And the employer's own evidence was they didn't explore alternative options, and the employee would just be dismissed if she refused. They'd offered no appeal. The dismissal was unfair. Now, this case emphasises the importance of following a fair procedure in any dismissal case, whatever the circumstances. The key issues in this case were the lack of consultation and lack of any reasonable consideration of alternatives to dismissal, including her offer to stay on existing terms and consider changes in the future if required. With a sound business reason for the change, all an employer needs to do is follow a fair process. For one employee, the tribunal said, this shouldn't have taken much longer than the 48 hours that she was given to sign her new contract. The employer, in this case, let their panic at COVID and their, quote, fury with the employee override the importance of a fair process. A remedy hearing will now decide just how much that mistake will cost. Now, if you're an employer thinking that you need to make changes to your workforce's terms and conditions, I have a small book on it, which you can get by searching on Amazon, and there's a direct link in the notes below. I've also got a 90-minute course online which takes you step by step through how to change terms and conditions, including the procedures needed for dismissing and re-engaging on new terms. If you're an employee and you're being put through the process, your trade union, if you're a member of one, will be a great source of advice. And here are some other sources of free legal advice. I'm Barrister Daniel Barnett. Please do like this video if you found it helpful and consider subscribing to this channel. There's a whole load of other employment law videos here, and here's another video I think you might like. Thank you for watching. Bye bye.